Good morning and welcome to Odyssey on WBEZ Chicago 91.5 FM, Chicago Public Radio. I'm Gretchen Helfrich. The court decisions of the civil rights era, most famously perhaps Brown versus the Board of Education, were critical to establishing a legal framework in which to advance an agenda of desegregation, equality of political rights, and other civil rights concerns. Those decisions laid down historic principles of law that continue to inform legislation today.
The Supreme Court gets case after case in the 1920s and the 1930s of the most grotesque brutality against blacks, meted out by Southern sheriffs and Southern justice and all that sort of thing. The Scottsboro Boys cases. There are a bunch of cases that, for professional listeners, I could list, like Brown in Mississippi and Chambers in Florida and all that sort of thing, where sheriffs say on the witness stand, well, we beat him several times, but he did confess. As if that doesn't violate any prescript of the Constitution. Well, if you're revulsed enough as a lawyer and a judge, you don't worry too much about the nicety. Is it equal protection or due process that's being violated? You say, this is just inconsistent with the constitutional design. I think that's the way a lot of the reasoning starts. And then after World War II, it really begins to take off, and it takes off as those decisions are developed. And as the NAACP mounts a serious and sustained campaign led by Thurgood Marshall to attack Jim Crow, mainly in the public schools.
Right. And one of the things that should be pointed out, the NAACP mounts a very systematic, thoughtful strategy to lay bare the contradictions that are already embodied in the doctrines and ideological structures that the court is working with. The second thing is, though, just to take a sort of a realist perspective, is that there's a lot of change going on outside of the court that the judges have to essentially take judicial notice of. I mean, you've got World War II, you've got the doctrines of Nazism that we are fighting against that start looking uncomfortably similar to what's going on back here at home. You've got African Americans who are returning from the war with certain expectations in terms of why is it that I'm now in uniform and yet am denied more freedom here than I was in France or Italy. And so you have a whole host of, I think, social conditions that are, that the court inevitably is influenced by. And I think it's important for us to realize that although Brown versus Board of Education may be one of those rare circumstances where the court is willing to get slightly beyond conventional opinion and sort of stake a place beyond sort of the political mainstream.
Conventional social opinion.
Social opinion.
Okay.
But that's very rare. And even in the case of Brown, I think that there were a lot of social changes, attitudinal changes of the sort that Dennis talked about in terms of the distinction between political equality and social equality. A lot of that baggage has to be eliminated before you see the Supreme Court being willing to venture out, into the areas that it did.